Welcome to this personal tax roundup for this month. My name is Dean Wootten. First up, we've got subsistence expenses, and this was a case NWN Solutions Limited. Now, this appeal related to employee subsistence expenses using the HMRC scale rates. Employees were required to submit the company's standard expenses form, which stated receipts did not need to be submitted. They had to confirm that by making the subsistence claim that they'd been on a business trip, etc. And if receipts were required to support that business cost, then you would be able to provide them. But they didn't have to provide them when they made the claim. They were effectively using the HMRC scale rates. This form also contained a signed declaration made by the employee stating that I declare that this claim relates to the expenses incurred wholly, exclusively and necessarily in the course of my work. Now, HMRC issued determinations for just over £500,000 on the basis that the payments were not reimbursement of expenses specifically under a dispensation. In their mind, HMRC's mind, they were round sum allowances with no evidence supporting the expenditure incurred, and that made them liable to tax and national insurance. Now, first they looked at this and they said, well, the company's dispensation was in full force and effective throughout the relevant period. And if the relevant conditions are met, the dispensation removed the payments from the charge of tax. And the dispensation included HMRC's scale rates to be used for subsistence claims. And under the scale rates, receipts are not required. Why have scale rates if you need receipts? It defeats the object of scale rates. So first here said, well, the form signed by the employees, it is slim evidence for sure, but on the balance of probabilities, the expenditure was properly incurred on a business trip using the HMRC scale rates. They weren't round sum allowances. And HMRC were not permitted to impose best practice conditions requiring the validating of expense receipts, which were not specified in the dispensation agreement. So in the end, quite a sensible decision. Next up, we're going to look at an IR35 case concerning a tennis commentator. And this was Cranham Sports LLP, and it was concerning Barry Cowan. Barry Cowan is an ex-professional tennis player, and I think he's famous for taking Phil Sampras to 5 sets just before he retired. He retired in the early 2000s. He's been a commentator for Sky, amongst others, ever since. And Barry Cowan was a member of the partnership intermediary Cranham Sports LLP, and he commentated for, in the main, Sky. Now, HMRC issued determinations for the years 14-15 through to 18-19 on the basis that IR35 applied. HMRC invited the LLP to take up its offer review and made a without prejudice approach to the LLP to settle the dispute. Now, having confirmed the determinations have been validly raised, HMRC gave the LLP's advisors a 30-day window to request a statutory review or to notify the tribunal of their intention to appeal. Now, despite ongoing correspondence, no appeal was made until the 10th of March 2022, and this was 60 days late. So this wasn't really, in the end, a case about whether IR35 applied or not. This was a case about whether the tribunal should allow a late appeal. Now, HMRC's letter stated the need to act within 30 days, and there is a response by the 22nd of January 22. Now, the advisor continued to lock horns with HMRC, and they considered their conduct to be outrageous. And they didn't appeal until the 10th of March 22, which was significant and serious in terms of delay. Now, the reason for the delay was due to human error by the LLP's advisors. Unfortunately, that's not an adequate reason. The tribunal concluded the sum at stake and the loss of the opportunity to challenge that sum did not carry significant weight. And in IR35 cases, it was inappropriate to conclude that anything other than success is likely to be arguable. So they're really applying the late appeal criteria within the Martland case. It's got to be fundamentally disadvantaging someone to not let them have the late appeal. In this particular one, well, they didn't have that good a reason for the late appeal. And also, it wasn't guaranteed that they'd win it anyway, because IR35 could go either way. So they haven't met, they haven't satisfied the first tier that they should allow the late appeal. So unfortunately, in this particular case, the late appeal was denied and IR35 applied. It's a shame, really, because we'd have liked to have seen the facts of the case. But unfortunately, it was all about late appeal, and they didn't meet the conditions for late appeal. Obviously, in practice, we're trying to avoid that situation, and we always get our appeals in within time. But when you miss that, then you're going to have to look at the Markland case and just see what the courts will consider for late appeal. We'll now look at a case concerning foreign special dividends, and John Buckingham held shares in the Dr Pepper Snapple Group, who merged with the Keurig Green Mounting Inc. And he received 110,000 special dividend just before the merger, and included it all as a capital disposal on his tax return. Now, HMRC received information confirming that $29.50 of the $103.75 dividend was income, and they issued a discovery assessment treating $29.50 of the dividend as a distribution, and I think that's fair enough, and the individual probably should have done that. Some of it was dividend, some of it was capital. Now, under statutory review, they found that HMRC found that the full 103.75 should be treated as income for UK tax purposes. Now, Mr Buckingham quite rightly appealed, accepting the initial income split, i.e. $29.50 that was the income element, and the balance was capital, but disputed that all of it was capital. He couldn't see how that could apply. Now, the tribunal found that under Delaware law, as a matter of fact, $29.50 of the special dividend was income, and $74.25 was capital. The income proportion of the special dividend was funded by earnings and profits. The balance was funded by external investors, and so was capital. Indeed, the balance of the dividend, it couldn't have been dividends, income distributions, because there wasn't sufficient earnings or profits there. So therefore, the documentation from the IRS was valid, and HMRC should have listened to it. Now, the first tier was very critical of HMRC's review work on this. The office had failed to take into account the official IRS forms confirming the income versus capital split. The officer ignored notes in the company's accounts explaining the nature of the dividends. And when considering the documents after the hearing, the tribunal stated that it appeared that the review decision was actually made out of time. So when you wrap the all up together, HMRC's original assessment, when you had the smaller amount, the $29.50 as income, and the $74.25 as capital, that was upheld. So essentially, if you do have anything of similar nature, you go with the paperwork. If the paperwork says this much is income and that much is capital, then obviously that's what we'll do. And you'd expect HMRC to fall in line with that. We'll now look at an SDLT case, a very popular area, this one. Now, in March 18, the company bought a property for $2.8 million, and that included a main house, a lodge, outbuildings, an area previously used as market gardens, orchards, gardens, etc., and woodland that formed part of a large area of woodland known as the thicket. Now, the SDLT return was submitted on the basis this was a residential property, which is obviously quite high SDLT rates. It was later amended to be classified as mixed use, i.e. the non-residential rates, on the basis that the woodland made the whole purchase non-residential. And the claim was for just over $200,000 of SDLT overpaid. The HMRC disagreed and they denied the refund. Now, the first to agree with HMRC find the whole property, including the woodland, was residential. There's no evidence of it being used commercially. And following the recent cases of Hyman and Goodfellow, grounds does have a wide meaning, reflecting the character of the property. Now, the woodland formed a natural hillside barrier between the main house and the River Ouse, and provided privacy and security to the house, as well as enhancing its setting. It's very much part of the house. Now, the company appealed to the upper tribunal, arguing the woodlands were inaccessible from the main house and would never be habitable for residential planning. Consequently, it must be non-residential. The upper tribunal weighed up the pros and cons of referring back to the decision to the first tier for reconsideration on various grounds, but in the end they said, actually, we're not going to do that. We're going to remake the decision. And the decision was remade on the basis that there's no evidence supporting the woodland's use or exploitation as anything other than that of a woodland. The woodland did provide privacy and security for the main house, for the same reason as reached by the first tier tribunal. The woodland was within the legal title of the property, and the woodland was not excessively far away from the house, and its size and location increased the privacy and security of the property. So on balance, the woodland formed part of the grounds, and residential SDLT rates applied. Sticking to SDLT, another case. This was a case concerning Amajit and Tajinder Mudan, and they bought a property in London for 1.755 million, and they paid residential SDLT rates. Now in July 20, they amended their return, arguing the property was not suitable for use as a dwelling, and therefore non-residential SDLT rates should have applied. Now they argued, and I don't think it was disputed, that the house was infested and was not safe to live in. It needed a rewire. The boiler was hanging off the wall. There was a hole in the roof letting in rainwater. External doors and windows were broken and the basement was flooded. So it was in disrepair. The couple moved in with their family once the building work was partially completed. Now, following an inquiry by HMRC, a closure notice confirming the property was residential was issued, and the taxpayers took this to the first tier. Now, at the effective date, the property had been used relatively recently as a dwelling and was structurally sound. The tribunal acknowledged that before a reasonable buyer would consider the property ready to move into, the work would have to be undertaken. But the statute counts a dwelling as any building which, at the effective date, is used or suitable for use as a dwelling, is in the process of being constructed or adapted for such use, or is to be constructed or adapted for such use by the seller. So in their mind, first his mind, the property was a dwelling, as it had been recently used as a dwelling, and while empty, it had not been adapted for any other purpose. None of the work required was sufficiently fundamental to make it a non-residential property. So therefore, residential rates were in point. There has been a similar case, which this may well have prompted this, where it was a completely derelict bungalow, completely derelict, and they got the non-residential rates because it wasn't fit for habitation. So you've got to look at cases like this and just say, well, is it, has it been occupied recently as a dwelling? If it has, you're kind of struggling. But if you've got a fully dilapidated derelict property, there's not a lot standing of it, then really the non-residential rate should apply. If it looks like a house, like this one obviously looked like a house, it was in disrepair, but it certainly looked like a house, then the chances are that's going to be a dwelling for SDLT purposes. We'll now look at the duty of care case. Now in this particular case, the appellants were members of an LLP, or of LLPs, formed to acquire and exploit film distribution rights. And the scheme was marketed on the basis that the investor would receive tax relief for trading losses the LLP was anticipated to make, and those losses could be set off against their personal income or capital gains. And Mr. Thornhill was engaged by the scheme promoter to provide opinions on the tax consequences. HMRC argued the LLPs were not trading on a commercial basis with a profit, and the investors entered an agreement, settlement agreement with HMRC. So that was all sorted with HMRC, but they then brought a claim against Mr. Thornhill under the tort of negligence. Now, his advice to the promoter, which was communicated to them, was negligent in their mind, and he had breached their duty of care he owed to them. Now, the High Court dismissed the claim that no such duty of care existed. Even if it had, Mr. Thornhill's advice would not have breached it. Now, the case moved to the Court of Appeal, and they applied the assumption of responsibility test. Was it reasonable for the investors to have relied on any representations made by Mr. Thornhill? Should Mr. Thornhill have reasonably foreseen that it was likely that they would do so? Now, there were factors pointing towards the existence of a duty of care, but on the balance, the factors weighed against the appellants. Now, crucially, the tax analysis were qualified by the statement that the prospective investors are advised to consult their own tax advisors. Mr. Thornhill only consented to his advice being made available to the prospective investors on the basis that they took their own advice. Essentially what he's saying is, I'm not advising you. So therefore it is up to you to get your own advice. It was therefore unreasonable for the investors to rely on Mr. Thornhill's advice, and therefore no duty of care arose. Now, the second ground for it wasn't necessary for the Court of Appeal to consider this, but they did, namely that Mr. Thornhill's advice was so negligent that it breached the duty of care. Now, remember, he hasn't got a duty of care. Now, the Court did address this ground, just for completeness more than anything. Now, it criticised the unequivocal terms in which Mr. Thornhill expressed his view that the LLPs would be traded on a commercial basis with a view to profit, without identifying the risk of HMRC challenging that view. If the High Court had properly considered the matter, it could not have concluded that no reasonable competent tax silk could have expressed such an unequivocal view. Accordingly, the High Court had been wrong to conclude that had the duty of care been owed by Mr. Thornhill to the appellants, it would not have been breached. Effectively what they're saying is that had there been a duty of care, it would have been breached. But unfortunately for Mr. Thornhill, there wasn't a duty of care because he wasn't providing his opinion to the investors. He specifically said the investors must get their own tax advice. So it's quite important that we get those caveats in. Those caveats give quite a lot of protection. And in this particular case, Mr. Thornhill's caveat gave him the protection against these claims from the investors. Well, that concludes the personal tax roundup for this month. My name is Dean Wootten. Thank you for listening.